This is Scott Becker with the combined episode of the Becker Private Equity Business Podcast and the Becker's Healthcare Podcast. We're thrilled today to talk to Amber Walsh. Amber's on the executive committee at McGuireWoods. She also lives at the intersection. She headed up the healthcare department at McGuireWoods for a long time, working with this great mix of hospitals and health systems, physician-driven organizations, and private equity funds that have invested in healthcare. One of the most recent issues that's being discussed is the FTC has proposed and has asked for comments on banning non-competes. And so as background, some states do ban non-competes in certain contexts. This would be very broad. Amber's going to talk about that. The FTC, in response to this proposal, has received 26,000 comments that they're now considering. And a lot of those are from people that are health systems, physicians, hospital and healthcare organizations, as well as private equity sponsored groups and so forth. Amber, let me let you take it away from here and tell us what we're seeing in the FTC non-compete issues and if there's any sense of what could possibly happen.
Yeah, very happy to, Scott. This is a fascinating situation. So the FTC announced the proposed rule on January 5th, and it was really absolutely an unprecedented move to make some federal regulation around non-competition covenants. And it really sent, I would say the industry, but all industries, into quite a tizzy trying to interpret what this meant and what might happen. So from January until the comment period ended, which they extended at least 2 times, that comment period ended just this past Wednesday, April 19th. For that 3.5-month period, there was a ton of activity, a lot of coalition building on both sides of the issue. But the basics of the rule, just to explain what they had proposed, is a complete and utter ban on non-competition covenants in the employment context. So between employer and employee. Number 2, a rescission, taking back, striking any non-competes between employers and employees that were already in existence. And then third, an exception for that for a sale of business context. But even that was very limited. So in that instance, the proposed rule says that you can have a non-compete if you're selling a business. And this is in any industry, but certainly healthcare has had a lot of attention on this. But the FTC said the rule would be, in their proposal, you cannot bind somebody in a non-compete in a sale of business context unless they own at least 25% of the business. That was the proposal. But when they invited comment, they invited several different alternatives of, hey, this is the rule as we think it should be. But when you comment, go ahead and comment on all of these other different machinations of a possible rule. But again, very, very unprecedented because, as you said, this has typically been an area of law that is completely state-driven and varies a lot by state.
Yeah, so this would impact, I'm going to ask you a question. On the hospital side, hospitals have lots of employed physicians, many of which have non-competes. Physician groups have non-competes. Every private equity transaction typically includes some kind of non-compete. Not every transaction, but a lot of them, with the founders, the sellers, the employees, sometimes more to senior employees versus junior employees. So it affects a wide swath of business that uses non-competes. Now, there are some states where non-competes for employment are basically illegal, and people try other ways to work around that to try some restrictions or protections. But I guess the question is, this is largely been a state law issue to date. Does the FTC have the right to do this? What are people saying about that?
Yeah, that is a huge part of the comments. So what typically happens in the rulemaking process is there are always substantive comments. When an agency proposes a rule, there's a designated process to follow. And there are always substantive comments. I don't like the substance of the proposed rule because of ABCD. But in this case, and you do see this in a handful of proposed rules, There's an additional challenge going on, which is around the FTC's authority to actually rule make in this area. The FTC, when they put out the proposed rule, they cited some rationale for why they believe that this is within their jurisdiction. But the comments that were in opposition of the proposed rule absolutely went to a violation or spoke to a violation of the traditional kind of checks and balances, so to speak, of who gets to make these type of rules. This is not a new concept. This has been going on for generations, really since the founding of our country, that there's been this dynamic of who gets to speak on a certain issue. Is it state? Is it federal? Is it Congress? Is it congressional authority having been granted to an agency? So there's going to be a lot of debate around this. And of those 26,000 comments that you referenced, there were a lot of individual comments. So there were a lot of really tug at your heartstring comments from individual physicians, very compelling individual stories. But then you have these very large and well-reasoned comments from Chamber of Commerce is the biggest opposition. They organized a big coalition around this. And within that coalition, there are a lot of healthcare trade associations in there representing different types of providers or manufacturers or suppliers. They have their own set of well-reasoned comments on why this is inappropriate and why this would harm the healthcare industry in particular. But of course, this, the rule itself reaches beyond the healthcare industry. So what's going to happen now is the FTC will review and process, meaning like mentally process, all of the comments. They have an unlimited amount of time to do that. They will take as long as they want to take to do it. And while they are taking their time to process and consider the response, the law is not in place. Their proposed rule is not in place, meaning state law still applies. So what we're seeing happen on the ground is, and talking to our healthcare litigators at the firm who are still having to deal with non-competes, judges are still enforcing non-competes based on their own state law. That's not going to change for a while until the FTC decides what they want to do with this rule. And everyone expects there will be some rule. They might modify their original proposal, but everyone's generally expecting that they're not going to just drop this. They're going to put something out. And when they do, it will almost certainly then go through a legal challenge. The Chamber of Commerce and the coalition that they built have pledged to challenge it. So we can expect to see this lasting a very long time. Quite possibly could end up being a Supreme Court issue. So for now, we are watching it and we are following state law. We have to be aware of it because this is a shift. This is a big deal. It's just a big deal in philosophy and movement, not yet actually impactful and certainly not resolved.
And so when you look at this, and so fascinating, what is, for example, what is the American Hospital Association saying about it, or the American Medical Association? Are they commenting on it?
Yeah, so some of them have joined, and I actually don't know the American Hospital Association. I am guessing, I've got the list right here in front of me, Scott, of all of those who have joined the Chambers Coalition. I would guess that's where the American Hospital Association sits, but certainly lots of the trade associations for individual provider types have absolutely been in support of the continuation of non-competition covenants. They have been in favor of continuing non-competition covenants, which is anti the FTC rule. Right.
So the FTC has come out against the FTC rule. The AMA, I'm looking up, but the AHA has come out against this. And so that's their perspective. And so we'll have to see what the American Medical Association is saying, which could easily have a very different position on it as well, because it's a different perspective than is the American Hospital Association, which is a lot of the non-competes that are out there would be by the hospitals in favor of the hospitals to prevent executives and physicians from competing, which the AMA has got a much more nuanced position in terms of, I assume, they couldn't come out against the FTC on this, because a lot of physicians probably would like to get rid of non-competes. What a fascinating mix of a situation.
It really is. And thinking about this from an investor standpoint or from a employer in the medical community standpoint, you're in the midst of negotiating right now. You're negotiating the purchase of a practice, building a surgery center from scratch, a large private equity deal. And you have historically put value on the non-competition covenant in order to protect your investment and in order to kind of substantiate the money that you're putting into this business, the trade secrets, all of that. If you are of that type of participant in our healthcare industry, this is nerve-wracking. But what we're seeing is people are continuing on, including non-competes in their documents, because this is so unresolved, and it could be unresolved for a very long time. What we are encouraging anyone who is at that crossroads and considering, what might happen to my business were this non-compete to be rendered unenforceable. We're encouraging them to first consider your own state laws. State laws over the past several years, many have gotten tighter on non-competes already. And that's something that obviously everyone should be considering their own state laws. And then really having a heart-to-heart with yourself of, is this deal as I valued it? Or is this physician relationship as I have contemplated, is it still going to have the same value to me if I find myself with this person as a competitor on the other side? And are there other ways that potentially I might protect myself? Those are the conversations that are happening deeply within the private equity industry and the healthcare industry.
I mean, 100%. When you see this kind of thing going on, people look at how are all the other ways we could protect ourselves if we invest in something or employ people and we don't have non-compete. Just for the record, for our audience, both the AMA and the HA, with the AMA being a little more nuanced, have both come out against the FTC proposed rule to ban non-competes. So people hear that. Both of them have come out against the rule to ban non-competes. Fascinating. And the AMA did acknowledge that some of the members have different opinions on it, but they did come out saying that the FTC shouldn't ban all non-competes. It should be left to the states. Fascinating perspective. Amber, anything else you'd like to share with us today on this issue of the FTC's proposed ban on non-compete, the 26,000 comments that have come in response to it? And I guess it's very hard to have a crystal ball on what's going on with it. But in the meantime, companies are trying to protect themselves in case non-competes wouldn't be around.
I think the only thing that's really certain is that this issue is not going away. There's almost zero chance the FTC is simply going to drop it in response to the comments. It is almost a certainty. They knew when they issued the proposed rule, they knew that they were going to have a bit of a fight on their hands. There was a shakeup. One of the commissioners actually who dissented from it actually resigned from the FTC. They were fully prepared for a bit of a battle on this. So I think that's the one thing that I'm sure of, is that this is not going away and it's not getting resolved anytime soon.
No, that they will do something. Fascinating perspective. Again, I want to thank Amber Walsh for joining us today on the Becker's Healthcare and the Becker Private Equity Business Podcast to talk about the FTC rule proposing the ban on non-competes and the 26,000 comments that have been sent in response to it. Fascinating. Thank you so much.
Thank you.